Hi, I'm Shan Wu, and welcome to an Undercover of Law hot take on Trump's second try at getting Judge Juan Merchan to recuse himself from presiding over the Manhattan District Attorney's election interference case against Trump. Now, since there are quite a few election interference cases pending against Trump at the moment, let's remind ourselves that this is the one that was the earliest. It arose in 2016 when he paid actress-director Stormy Daniels money for her to remain silent about their affair. At that time, the Trump campaign was reeling from the video played from Access Hollywood, in which Trump bragged about being able to grab women by the genitals without their consent. And this was only weeks before the election. And the feeling in his camp was likely that the reveal of an affair he was having while his wife Melania was pregnant might really end his chances of winning against Hillary Clinton. In that clip, Trump was so full of confidence and bragging about what he can do with women without their consent that it would look really bad for him to add on this additional bit of scandal. So, what did Trump do? Not unexpectedly, he allegedly tried to buy his way out of the situation by reaching a deal to pay for Stormy Daniels to stay silent. Now, there's nothing illegal about that. What makes it illegal are the two things that happened after that deal. First, the allegation is that Trump had his lawyer, Michael Cohen, make the payment, but then illegally tried to disguise them as a repayment to Cohen via legal services payments. Those would be false business records, and that's a violation of the New York false records law. Second, this payment also violates state and federal campaign finance laws because it was part of a so-called catch and kill scheme, which was done in conjunction with the National Enquirer, you remember them, for the purpose of helping Trump's presidential election by finding possibly scandalous stories and avoiding them getting publicity by catching them and killing them by paying people to stay silent. One of the other schemes alleged in the catch and kill involved former model Karen McDougal, who also said that she had an affair with Trump. McDougal also received a hush money payment. Again, nothing wrong with the fact that they reached a deal not to talk. What's wrong, illegal, is the way that they tried to cover this up. There is also an alleged payment to a doorman at Trump Towers to keep quiet about information about a supposed illegitimate child. Now, the whole point of campaign finance laws is to try to give transparency to campaign financing. Meaning that if something is being done to help a candidate's election, that should be made plain to the public and not concealed. So the problem with this scheme and the payments to Stormy McDaniels and others, like Karen McDougal, is it tries to hide the fact that deals were made to help Trump's campaign. And that's what constitutes the election interference violations. So this is why Alvin Bragg's case is very strong, because it's very simple. It will be easy for a jury to understand and for the prosecution to prove why Trump would want to buy silence about these alleged affairs, because their disclosure would hurt his campaign, so he'd want to cover them up. It will also be very easy to prove that Trump did not reveal these payment plans as campaign expenditures, but rather allegedly tried to hide them as payments to Michael Cohen, who was then his lawyer, for legal services, when actually these should have been considered to be campaign finance expenditures. And the district attorney's office has laid that out very clearly, including in a chart that they released for their public statement about the case. The strength of this case is likely one of the reasons why Trump is so desperate to avoid this trial starting. And it looks like it is going to start. That brings us to his latest desperate effort, which is to try for a second time to ask Judge Juan Merchan to recuse himself for the same reasons that the judge originally refused the first request. At the heart of Trump's argument is his claim that the judge can't be impartial because the judge's daughter works for a company that does political consulting and ads for Democratic candidates. It's all about the judge's adult daughter. Is Trump's second try any better than his first? I don't think so, but let's take a listen to what a former federal judge told CNN's Caitlin Collins. I'll give you my reactions to her point of view on the other side.
I'm joined tonight by a former U.S. District Court judge for the Southern District of New York, Shira Shenlin. And Judge, it's great to have you back on The Source here twice in 1 week, which shows you how many legal filings we're dealing with. I just wonder, what would your response be to a motion like this 10 days before you're set to go to trial?
Well, I wouldn't be pleased to get it 10 days before, but I had the chance to read the motion. And they've put together a composite of issues that would cause me a little bit of pause. And I can explain all the various things that they've put together. The main focus of this motion, as opposed to the previous one a year ago, which the judge denied, is on the daughter's line of work.
So respectfully, that's just wrong. It's not different from the previous motion. It's exactly the same. If you look at the first recusal motion Trump filed in May of 23, you can tell it's exactly the same. So here's what he said in his first motion back in May of 23. Your Honor cannot preside over this case for at least two reasons. First, the political and financial interest of Your Honor's daughter in authentic campaigns creates an actual or perceived conflict of interest because rulings and decisions Your Honor will be required to make in this case may result in a financial benefit to Your Honor's daughter. That's the first recusal motion, which was denied. Let's compare it to the second one, the one that he just filed. In the introduction, quote, Your Honor's daughter, Lauren Mershon, has a direct financial interest in these proceedings by virtue of her ownership stake and leadership role at authentic campaigns. So they're exactly the same. Now, that is something which the federal judge, with all due respect, seems to gloss over. So now let's take a look at what the federal judge thinks about this financial interest issue, because she seems to think that there is an actual financial interest in the outcome of the trial. Let's listen.
As you already said, the daughter does work with many, many high-profile Democratic candidates. She works on their social media. They put out a post. They get contributions. She, as an owner, gets a percentage of those contributions. So there is a statute in New York which says a judge must disqualify himself if a person known by the judge to be within the 6th degree of relationship, and a daughter is the 1st degree, has an interest that could be substantially affected by the outcome of the proceeding. So the question here is this daughter likely to profit, to benefit from the outcome of this proceeding?
So that's a good question to ask, but the answer is no. She doesn't have any interest in the outcome of the case. The only difference in this latest filing is that Trump's lawyers did put in a whole bunch of colored tables to show, looking like a brochure, that her company does do political ads for Democratic candidates. But the fact that they do ads for candidates has nothing to do with having an interest in the outcome of the proceedings. Whether Trump is convicted or acquitted won't affect her political consulting firm's business at all. Simply put, they don't make more money either way. That's just common sense. But we don't have to rely on just common sense, because before Judge Mershon decided Trump's first losing argument, he consulted with the New York State Advisory Committee on Judicial Ethics about this very question. And he relied upon their opinion in rejecting Trump's argument. Here's what that committee actually said. Quote, the matter currently before the judge does not involve either the judge's relative or the relative's business, whether directly or indirectly. They are not parties or likely witnesses in the matter, and none of the parties or counsel before the judge are clients in the business. We see nothing in the inquiry to suggest that the outcome of the case could have any effect on the judge's relative, the relative's business, or any of their interests. That earlier finding, though, doesn't seem to sway the judge, because she goes on to say the following. Take a listen.
Into the daughter's financial stake in this company, Authentic, and how she earns money from the posts and from her work with these candidates. And it explains that she takes a percentage of the take. So when they advertise the arraignment or the indictment, and tens of millions come into these candidates around the country, she gets a percentage of that. So it's the appearance that is of concern to me. I'm not saying that the judge did anything wrong or will do anything wrong, and I'm sure he can be fair. But the question is, to the reasonable person on the street, is there an appearance of impropriety?
Another fundamental disagreement I have with her here. Making money from advertising the fact of a trial has nothing to do with having an interest in how the trial comes out. Apples and oranges. Under the judge's reasoning, you would end up thinking that news outlets have a financial interest in the outcome of high-profile cases because they get higher ratings for covering it and more advertising revenue. But there is one thing I agree with Trump's lawyers about here in their second attempt to get the judge off the case. And that is, one thing has changed since their last filing. As Trump's lawyers point out, Trump is now the, quote, presumptive Republican nominee. That is a changed circumstance. It's a changed circumstance that means nothing legally, but means a whole lot politically. Indeed, that might even be the real point of this motion, to be able to publicly smear the judge and his family without violating the gag order by filing public motions, meritless motions, but they do serve as fueling Trump's political tirades against his being prosecuted. And of course, it drums up the passion of his base. That's the only purpose served by these motions, to fire up his base, further his political campaign, and continue to fuel his fundraising, a large part of which goes to pay his legal bills. Oh, and there is one thing I agree with the judge about as well. Let's listen.
I realize it's 10 days before the trial and don't expect it to be granted.
Okay, so you don't expect it to be granted?
The judge is spot on with that one. The motion won't be granted. I'm Shan Wu. Thanks for watching this Undercover of Law Hot Take. I also want to say thanks so much for all your comments. They're really helpful, and I love hearing about your insights. And tell me what other topics you want us to talk about. See you soon.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram @MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.